I've got one member missing for purposes of decision making.
Hello, Chairperson. Yes, Chair, we're still waiting for one more member. Thank you.
South Africans, I'm still between a better place and the traveling point. So for now, I may be affected a bit in terms of video connectivity and so on. But as you'll be aware, we are starting with a subcommittee meeting on the SABC Board appointment process. And thereafter we would immediately get to a committee. In that score, I want to start by welcoming all members of the subcommittee, honorable members. Of course, those that are on the platform, in particular, those who have been following our deliberations by being on the platform. The legal team of Parliament would also be presenting this morning, as well as fellow South Africans who may be following our discussions in different ways. Honorable members, I will, without further waste of time, I think until I get to a point of connectivity that's better, and I must take the opportunity to just deal with the formalities of meetings on this platform. Just to remind ourselves that at all times our mics should remain muted, video cameras off until you are recognized by the chairperson of the meeting, who will then allow you to unmute and switch on your video camera, unless there may be challenges of connectivity, in which case you'll give an indication to the chairperson so that permission is granted for you not to switch on your video camera to maximize your bandwidth. Of course, honorable members are also reminded that as it relates to point of orders, the rules shall also apply, that a member would want to raise a point of order would not unmute the mic until recognized by the chairperson. In that case, would unmute, raise the point of order on which the chairperson could rule upon in terms of the rules. Of course, because there will be those that may be losing connectivity from time to time, as you reconnect to the platform, please ensure that at all times your mic is muted and your video camera is switched off, as mics are sensitive and therefore could pick up background sounds which may distract a speaker that may be on the platform. We're also guided, honorable members, not to raise unnecessary point of orders to a point of collapsing the meeting on this platform. Having raised those, I would want to check if there are apologies that would have been received by the committee support, so that we put those on record. Ms. Ndabeni.
Thank you, Chairperson. I didn't receive any apologies. Thanks, Chair.
Thank you, Ms. Ndabeni. Honorable members, just to indicate how we are probably going to proceed. As you would have heard in my acknowledgements, I did acknowledge also the presence of the legal department. And I take it that, yes, Mr. Tekana, it's one of those, but if he's got another person that's brought on board, we'll get that indication. Honorable members would be aware that in the course of us executing our work with regards to this process, there would have been submissions coming from members of the public, maybe through organizations or individuals, because an opportunity has been given to them to do that. And therefore, those that were received earlier, which were quite specific about objections on certain candidates that were to come before the committee after the advertisement of the listed candidates. So there was agreement, therefore, to refer those to the legal department as different matters would have been raised. The legal department would indeed advise us accordingly on those matters that have been raised. Subsequent to that, understanding that the closing date would have probably been the 22nd, there were others that were also received even as we were doing the interviews, reflecting on some of the candidates as the interviews were proceeding. We'll also have to put those on record so that they are also known as part of the public participation process, which is an important task that parliamentarians do, that of ensuring that there's public participation in the way we construct our laws, but generally in the work of Parliament. So we'll do that. That is also helpful, honorable members, in making a determination later on as matters would have been thus clarified. Would also get briefly a report on how far the vetting process is, as members would have also raised that as a point that would not want to get to situations that entities would have gotten themselves in, where appointments would have been made and the recommended people may not pass the vetting that gets done, even though it may be quite at a lower level in terms of what gets to be done, as opposed to other positions where there may be a need for top secret clearance certificates and so on. But we do need to get that briefing so as to help us take a proper way forward in terms of how we proceed from today. So I thought it's important that we do that, and therefore, as we do it, we will then be able to say what do we do given the status of the information. We do all these, honorable members, that we are not just about considering public participation, but we must be seen to have considered the views that are raised by the public when we make our recommendations to the House at some point. With that, I want to welcome the legal, as represented by Mr. Tejana. As I said, you'd indicate if you are also going to be joined by another person, or you would just proceed yourself to take members through on those matters that would have been raised. As I said, thereafter, we'll have to place on record what has been received from the public participation process, and then take the part from the committee support on the vetting process, and therefore make a determination on whether we're able to proceed to the next step or not. Thank you, Mr. Tejana.
Good morning, Chairperson and honorable members, and good morning to my colleagues as well. Perhaps, Chair, before I start, I should ask for your permission for my video to be off, because I think my connectivity is a bit suspect.
Yes, but at least we do know you. Even the voice doesn't seem to have been altered by robotics. You can proceed. Thank you.
Thank you very much, Honorable Chairperson. Chairperson, I think you have already sketched the background, but of course, I have to indicate to this committee that you had requested us as legal services to provide an opinion on disputes emanating from interviews related to the filling of vacancies for the SABC board. I think, Chair, as a start, we need to say that some of the things that we do are rooted in the Constitution of the Republic of South Africa. And I think, Chair, if you may allow me to refer to section 57, 1A and B of the Constitution, which says that the National Assembly may determine and control its internal arrangements, proceedings, and procedures, and make rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement. Now, Section 59(1)A takes it further to say that the NA must, it says must, facilitate public involvement in the legislative and other processes of the Assembly and its committees. Now, Chair, the aforesaid provisions are echoed in Rules 167D and F of the NA rules, which state that for the purposes of performing its function, a committee may, subject to the Constitution, legislation, the other provisions of these rules and resolutions of the Assembly, conduct public hearings, determine its own working arrangements. Now, Chair, if you look at Section 13(2) of the Broadcasting Act, Chair, it says that the non-executive members of the board must be appointed in a manner ensuring A, participation by the public in a nomination process, B, transparency and openness, C, and that a short list of candidates for appointment is published, taking into account the objects and principles of this act. Now, if we may pause a bit and go to Section 2A of the Broadcasting Act, which speaks to the object of the act itself. Now, that provision, Chair, says the object of this act is to establish and develop a broadcasting policy in the Republic, in the public interest, and for that purpose, to contribute to democracy, development of society, gender equality, nation building, provision of education, and strengthening the spiritual and moral fiber of society. Now, Chair, under the very same act, if you go to Chapter 2, Section 3(1)B, which deals with the South African broadcasting system, you will see, Chair, that from Section 13(4)A to D, it tells us what is the criteria that this committee must be seized with in making these recommendations. And it says that the members of the board must, when viewed collectively, be persons who are suited to serve on the board by virtue of their qualifications, expertise, and experience in the fields of broadcasting policy and technology, broadcasting regulation, media law, frequency planning, business practice, finance, marketing, journalism, entertainment, and education, social and labor issues. B, the persons who are committed to fairness, freedom of expression, the right of the public to be informed, and openness and accountability on the part of those holding public office. C, represent a broad cross-section of the population of the Republic. And D, the persons who are committed to the object and principles as enunciated in the Charter of the Corporation. Now, Chair, you will say that this commitment to the objects, and the principle of the Act, it comes back again. And of course, I've already dealt with Section 2A, which deals with the object of the Act. And I want to underscore, Chair, this commitment to the moral fiber of society, because, Chair, it speaks to, you know, when we interpret the Constitution, Chair, we speak about the object, purport, and spirit of the Constitution. So in capturing the spirit, Chair, we have to look at the document in its totality. Now, Chair, if we go to Rule 2271C, which speaks to the functions of a portfolio committee, and I think it characterizes, Chair, in a very pithy manner what our business today is about. Now, that provision, Chair, it says that a portfolio committee may monitor, investigate, inquire into, and make recommendations concerning any such executive organ of state. Goes on, constitutional institution, and so on. I won't cover it all, Chair. But I think the point I wanted to raise is the point there, which is also echoed in section 31, or section 13.1 of the Broadcasting Act, because it says the 12 non-executive members of the board must be appointed by the president on the advice of the National Assembly. Now, Chair, you've asked us, Chair, pointed questions regarding the suitability thereof of 3 candidates. Ms. Musala, Mr. Muhuba, Ms. Mbeki, and Ms. Pachi. Yeah, for 4. Chair, we need to be very clear on this. When this subcommittee or committee of parliament sits, Chair, it is not sitting as a court of law, Chair. It is sitting as a subcommittee of parliament with its own constitutional obligations insofar as oversight responsibilities, and Chair, insofar as generally it discharges its own constitutional obligations. Now, Chair, remember what the mandate of this committee here is not necessarily to make any finding, against any candidate. But the fact of the matter, Chair, and this is the point we've emphasized, is the point that you have a public participation process. The public has made submissions, and we say, Chair, that this committee, Chair, cannot ignore those submissions. This committee, Chair, must look at those objections, with an open mind, objectively consider them, and arrive at a particular conclusion. Now, Chair, one of the things which this committee has to do, Chair, and this speaks to one of the most important components of the rule of law, which is the rationality requirement. The reason why, Chair, I'm saying that this committee is not sitting as the court of law is that in terms of what is required of it, it has to demonstrate that whatever decision it takes, Chair, it is rational. And within that context or realm of speaking about the rationality principle, one of the legal principles which this committee has to display, Chair, is one which is founded on the principles of natural justice, which is the Audi rule. Now, the fact of the matter, Chair, is that we have submissions which have been submitted to the committee by the public, which of course we must consider. The second thing, Chair, is that the committee will have to inform us, Chair, whether these questions that form the substance of these allegations were raised during the interview process to the affected candidates, because that is very much important. Because you can't say, Chair, you are deliberating in order to make a view about something when the person against whom those objections have been made has not been informed, or these things were never even raised with him or her during the interview process. Now, Chair, as a matter of example, because I want to delineate in a very clear manner what this committee has to do. I will keep on harping on this point, This committee, Chair, is not a court of law. There are submissions in front of it which it has to consider. The fact that, Chair, someone has got a matter which is still running before the courts, it is not the business of this committee, Chair, to say that no, we will wait for the courts to pronounce in 7 years and so on before we take a view on you. This committee, Chair, has to make recommendations, and we know that the president is the appointing authority. This committee has to look at matters as they pertain in front of them now. In other words, Chair, out of the 600 or 60 whatever candidates that we have in front of you, would you still want to tie your hands to someone who already has findings against him without pronouncing on those particular findings. Or rather, you would say, let's go to section 13(4) of the Act and look at whether this candidate exhibits or possesses those characteristics which the Act requires. Because Chair, we don't want Parliament, Chair, to embroil itself on battles which are really outside of its remit. We don't want a Parliament, Chair, which will be saying that we want to interrogate, for instance, the report itself and see whether any avenue exists for the report to be taken on review, or for whatever finding which has been made against a particular candidate. This committee, Chair, is presented with information in front of it, which is serving in front of it, and this committee has a constitutional responsibility, Chair, to apply itself and its mind on what is currently serving before it. And I think, Chair, these principles that I've outlined, they speak broadly to what the committee has asked us in relation to the three candidates, which is Ms. Morsala, Mr. Mauba, and Ms. Mbeki. And I think the question about Ms. Patti, Chair, was around issues of conflict of interest. And I think, Chair, to aptly capture, I'm sorry, Ms. Patti's operations, it's one of those, and I'm talking about ACT, Chair, vis-a-vis the SABC. I'm talking about ACT vis-a-vis the SABC. It's one of those, it's one of unity and struggle, cooperation and contestation, in the sense that ACT, Chair, is not in direct competition with the SABC. ACT is not a monopolistic bloc with homogeneous interests. I mean, ACT is a conglomeration of independent network operators. ACT is an independent body, and as previously advised, which is not in direct competition with the SABC. And for that reason, Chair, we see no need why should Ms. Patti's candidature be denied on the basis that she happens to be the CEO of ACT. I think, Chair, for now I'll leave it there. But of course, Chair, we would want also to get a sense from the subcommittee whether during the interview stage, what is contained in the submissions was put to the affected candidates. That is very much important, Chair, in terms of process. And if Chair, that was done, nothing prohibits this committee to apply its mind, and of course, recommend candidates, Chair, who are fit for purpose, whose integrity and reputation, Chair, is beyond reproach. And I think, Chair, if you talk about moral fiber, Chair, you have to look at issues of strength of character, firmness of purpose, toughness of spirit, and so on and so on. So I'm just saying, Chair, you are not a court of law as this committee. You are a committee of parliament with its own mandate. Your hands can't be tied to the fact that a certain finding was made against me. I've appealed it to the SCA, in which case if the SCA pronounces against me, I'll appeal it against the Constitutional Court. If the Constitutional Court rules against me, I can also, Chair, there's something that I heard recently, rescission of rescission, you know. So my point is, Chair, this committee, Chair, is not, its hands are not tied. As long as we are not moving beyond the scope of what the Act requires us to do. Thank you, Chairperson.
Thank you, Mr. Dejana. I saw Advocate Jenkins, also from your team. I'm not sure if he's brought in to make input or just to be present. before I get to honorable members who would want clarities.
Chairperson, good morning. Good morning, honorable members and colleagues. Chair, I've got nothing to add to my colleague, Mr. Tatiana. I think he covered all the areas that we needed to as a team. So I was just here to support him in case he needed to be somewhere else. I had to be somewhere else, so I joined a little bit late, but thank you, Chair.
Thank you. As I said, I will now give to honorable members who would want to ask questions to the legal, but let me start by confirming that for those that were received, in particular, those that relate to the candidates mentioned, we have also used the interviews to put those questions to the candidates, and in that way have had an opportunity of clarifying not only the committee, but South Africans, because at the end, when we deliberate on the names to be recommended, South Africans would also be following that through. So Mr. Tichan, I just thought I should confirm that, including other candidates that may have come thereafter, where there were issues that came, we put it to them so as to get an opportunity to say their side of the story, the out that you referred to. So I just thought I should clarify that.
Thanks, Chair.
Thank you. Honorable members, I saw Honorable Kolabanet followed by Honorable Majosi.
Thank you, Chair. I just wanted to confirm, and in fact, you've just said it, that the issues that have been raised about those three candidates were raised. I certainly raised them. I'm sure others raised them as well. They had every opportunity to explain their side of whichever story. So I think that was aired as well as could be expected. Thank you. That's all I wanted to add to clarify for the legal advisors. Thank you.
Thank you, Honorable Kolabanet. Honorable Majosi, you'd be followed by Honorable Mlala.
Thank you, Honorable Chairperson. Good morning, honorable members. No, my question would be one. I heard that the legal was saying public, it must play part in terms of seeing that the process unfolds in a proper manner, and that obviously people who will be people who might their service be taken are people who qualify for the board of the SABC. My question is then that does it not conflict with what the public now is in participation of? Because if we're saying we've shortlisted people that qualified, it's an obvious case, and people that must maybe would be in the board of the SABC. And the public also, on the other side, it has a say on what happens throughout the process. Will it not then be a problem if we say what on our side, we are not legal, we are not the court of law, we have just done the process of shortlisting people who qualified, and ignore what the public has raised in terms of the other people who have submitted their CVs and so forth and who have been shortlisted. So I just wanted to get a clarity on that one. Will it not be a problem on our side as a committee that we ignored what the public was warning us about and so forth? If they can just give us a clarity on that, and then I'll be fine. Thanks, Chair.
Now recognize the Honorable Mlala, who would then be followed by the Honorable Dr. Basop.
Yeah, Chair, thanks very much. And good morning to my colleagues and the Chair. I think I am quite happy with the legal opinion, but I'm also saying that the opinion was necessary because there were outcries all over about certain candidates and so on. And the legal opinion says to us, this is the advice they can give us, but the final decision will still remain with us as to what do we do. But Chair, I want to hasten to say that it's quite interesting that some of the people that alleged to have done wrong things have been in the board for some time, and the very same public opinion has not done anything until we started the process of interview. So from where I'm sitting, I think the legal unit has done their part. All that is left is for us to look at what they have presented and make a decision. I don't think we should worry more about what they are saying, because the public also has the right, as much as it has the right, people can still abuse the very same public for their own means. So that's why it's necessary for us to also have a legal opinion. And for me, that opinion is quite fair. And I really appreciate it. Maybe at a later stage, we can then engage ourselves as a committee and find a common ground as to how do we move forward. But for me, I really appreciate their presentation. Thanks, Chair.
Thank you, Honorable Mlala. Honorable Dr. Basop, you are recognized. You can proceed.
Thank you very much, Honorable Chair. Good day, honorable members as well, and the team that is there. Firstly, Chair, let me apologize to join a bit later. There is a problem of network. Where am I? Chair, perhaps I might have lost some points that have been put together by the legal opinion. First, Chair, my position here is that even myself, I'm happy with the legal opinion. But again, to remind ourselves that what is our role in this exercise? My understanding, we are not employees, we are not appointed. Ours is to assist a particular process by going the route that we're on. And also, Chair, my understanding is, though I've been trying to get from my the package that I have, there were terms of reference for us as a committee. And therefore, somebody down the line is responsible for the appointment, not us. The final word is not with us. But the only thing that I want to check, is there any harm when we are presenting our report with the scoring and all that was expected from us? Is there any harm, I mean, to save our backs, to say, here is our report, but on top of this, there are these submissions that were submitted by the public, something like that, of that nature, Chair, to say that we should not be seen as the people who are hiding side information with us, because this information was sent to us, and therefore, for me, we're supposed to package this information with the report, but not to say we can't recommend so and so because of this. That's my submission, Chair. Thank you.
Thank you, Honorable Dr. Basop. I'm not sure if the legal would want to have responses to the points raised thus far.
Okay, thanks, Honorable Chair. I think Honorable Kola Panat made a comment, Chair, which is what you made as well, regarding that during the interview process, these matters were put to the candidates. And I think Honorable Majosi, Chair, speaks about whether the submissions can be ignored or not. And you will see, Chair, that in paragraph 33 of our opinion, we say that the subcommittee cannot ignore the submissions that have been made by the public regarding the suitability or otherwise of the candidates in question. The subcommittee has a constitutional duty to consider them, and the only legal requirement is that it must do so within the bounds of rationality. You see, Chair, when you're talking about the rationality requirement, Chair, the threshold, Chair, there is very low, Chair. In other words, even courts, Chair, when they look at it, they do not necessarily say that the option you've chosen is the right one or the correct one. All they want, Chair, is for you to map out a map, Chair, which shows that when you considered these things, Chair, you were rational. That's why, Chair, we quote, I mean, a judgment of the Constitutional Court in the Albert matter, where we say where the court said, courts may not interfere with the names selected simply because they do not like them or because there are other more appropriate means that could have been selected. But where the decision is challenged on the grounds of rationality, courts are obliged to examine the means selected to determine whether they are rationally related to the objective sought to be achieved. So, Chair, the threshold for the rationality test, Chair, it's a very low threshold. It's just a question of demonstrating that in whatever step that you took, Chair, you were rational. Chair, you will recall that there was a Constitutional Court case between the former President Jacob Zuma. In fact, the citation of the case, Chair, is the DA, Democratic Alliance, versus the NDPP, which was at the time, remember, Mr. Mins Melane was appointed by the president using his powers, of course. And if you remember, Chair, Judge Yakub, the Constitutional Court there, in a judgment written by Judge Yakub, set aside that decision, Chair, on the basis that there was a Ginwala commission, even though the Ginwala commission, Chair, was not a judicial commission of inquiry. But the court said the fact that you ignored the fact that there were statements which were made in the commission which spoke direct to the character of the candidate himself. So my point, Chair, is that to sum it up, Chair, without wasting the committee's time, there's lots of cases that deal with these principles. But without wasting your time, Chair, I think the point that we're making, Chair, and we're making this point, Chair, very firmly and very vociferously, Chair. This committee, Chair, cannot ignore these public submissions. It has to consider them, Chair. And I think regarding Honorable Mulala, it was a comment, Chair, and we welcome it, Chair. And I think the points that I've spoken to also speak to what Honorable Dr. Pasop has said. That, Chair, look, this is a responsibility you can't run away from, Chair. This subcommittee, Chair, has to look at these submissions and consider them, Chair, whatever decision that they make. I'll stop it from there, Chair. Now, I'm not sure if my colleague, Advocate Jenkins, want to add anything. Thanks, Chair.
Chair, with your permission, I've got nothing to add. Thank you, Chair. Thank you to my colleague as well.
Thank you. May I just check if there are follow-up questions? I see Honorable Kola Barnett. Any other member would want to follow up after those clarities? Okay, that seems to be the one. Please proceed.
Thank you.
So that
Thank
we
you.
get to the next presentation.
Thank you very much, Chair. Yes, I'm very happy with the legal inputs, particularly the one that says that we must be careful not to tie ourselves to an issue or embroil ourselves in battles outside of the mandate of Parliament because of this business that legal processes may run for 7 years. I think that kind of says it all. But something I would like some input on, I was very concerned to read a very long piece which quoted the minister extensively that came out on Sunday. So just before we're doing this process, and her threats to declare the current board delinquent for reckless trading. And it went on to failing submit a requested revenue plan in June this year, talked about the losses, the decline in revenue. But, you know, she's demanded a plan now 10 days before the current board is dissolved. And if she goes ahead and goes through some process or through with her threats to declare them delinquent, is she not trying to influence the outcome of this particular decision and decision-making body? I don't think it was appropriate for the minister to come out publicly with such threats shortly before this very process, because it may well, if one factors it in, it may well have an impact on our final decision. So we have 4 or so sitting members who are standing again. So I would like your input on that. It's very bizarre that it would come out exactly. I don't believe in coincidence. So I'd like your input on that. As far as I'm concerned, we need fit for purpose people, men and women beyond reproach. That's it. Thank you.
Just check if there's any other member. Okay, no other member. You can then proceed to respond. Mr. Tejana and Advocate Jenkins.
Look, Chair, I think this is beyond the scope of our legal opinion, Chair, and I think it would be unfair of me to make comments, Chair, even on a statement I haven't even have sight of.
I think that point, it's a valid point, Honorable Kolabana, so that I didn't want to respond. At least they would have responded to it, that they worked on information available. And this may be something that has just come through. And I take it that it has no bearing on the work of the committee unless there is a decision in that regard that declares any of the current board members delinquent. And I take it that they would respond themselves to that matter, because it's about accountability in the current phase, not on the board that we are looking at from the side of the committee in assisting the president to appoint people that are fit for purpose, as you correctly say. So the legal has now given us a sense, honorable members. Like I said, would also have these others put on record. Maybe just to tighten up that point, Honorable Dr. Basso, I think in a transparent way, when we report, we must report comprehensively, which will also take into account what has been received and the fact that we didn't just look at them. Indeed, we must be seen to have considered the views of the public as part of the public participation. But the ultimate recommendation rests with the committee having applied its mind on everything else that has been presented before the committee within its mandate and what the law also requires of us to do in this regard. So if there are no further questions, I think for the legal unit of Parliament, I think we should thank them that they've guided us because they can't make the recommendations we need to make, but they've guided us. They've clarified the point that we are not a court of law. But secondly, we cannot ignore the comments from the public. But they've also made the point that we make the recommendations to assist the president. And it must be proven, I think, that we're rational in the way we considered those vis-a-vis the recommendations that we make in terms of names. So that would be really my take, honorable members, so that we do release them to do other work. Is that clear?
Thank you, Chair.
No. Okay, we'll then release. Honorable Mlala wants to speak before you are released. Honorable Mlala. Honorable Mlala.
Yeah, thanks, Chair. I hope I'm not delaying them, but the chairperson, I think you responded well to Dr. Basopu. I just want to emphasize one aspect of your response, maybe for purposes of the legal team, because it will not be proper for us to attach all the information when we have the authority to deal with them. Because the reason they are brought to us is that whatever recommendation we make, it's on the basis that we have considered everything else, the public, the legal opinion, the interview process, all these things, we have considered them as a committee. Now, taking the matter to the National Assembly and to the President, it will not be proper from where I'm sitting that we recommend a name and also write something besides the name. Because then the President can easily return the matter, but you have not dealt with this issue. So from where I'm sitting, we have the responsibility. That's where I fully agree with the legal opinion. We have the responsibility to look into all these matters, and from where we are sitting, have a clear decision that after having considered all these things, this is our recommendation. But we can then put those issues into the next level, because then it will be, I don't know what is the best way. It will be responsible of us, because it's supposed to be our responsibility to deal what the public raised. They raised them with us as a committee. Whatever the legal opinion is raised with us as a committee. So we as a committee must finalize the matter in our little wisdom, and then present, because it does not stop any other process. It doesn't stop any other process. The same people can still write to the President after our recommendation if they are not happy, for instance, with our recommendation. They can still write to the National Assembly, whichever way they want to raise their matter. So from where I'm sitting, I think maybe I don't know if I'm spoiling your summary, Chairperson, but I hope I'm still within the bound, because you summarize it properly, but sometimes you are a bit diplomatic. So I wanted to get meat out of your presentation, Chair. Thanks, but I just wanted to emphasize that part.
Yeah, maybe the legal would still want to come to the point. Respectfully, yes, you are. The point is, in response to Honorable Dr. Basop, it's a distinction between what you recommend as a decision and a report. The report cannot ignore that the committee did consider what has been raised. It did get a legal opinion on some of the matters raised. So that when you recommend the names, it's not like you ignored anything that has been raised, but you've applied your mind on all facts available before you. That's why even the part about the minister, I didn't want us to entertain, because necessarily it has no bearing on how we need to proceed as a committee. So in that score, I think for me that suffices, because it was a response. in any way all the reports, that's how we write them. We do indicate at a particular time that this is what we did. We opened this for public comments. Yes, we did receive public comments. Of course, we don't attach letters, but do a summary of the report. And it has nothing to do with the ultimate recommendation. Because by the time you get to the recommendation, the case that was cited, you don't have your decision reviewed and set aside because you did not apply your mind to what is before you. Because that's what it does. But if you've applied your mind with what is before you, you would be able to defend the recommendations that you make, in that you've considered everything before you, for which the public comments are one of those who would have to consider. The legal opinion, it's one of those things we have to consider. So that's a summary, honorable members, so that we do not start discussing even the names, but just deal generally with the principal matters. I hope I'm out of the diplomacy, Honorable Mlala, and that there's clarity.
No, you are there. Thanks, Chair. Yeah, you are
Yes.
now.
So if the legal department would still want, like Honorable Mlala would have raised, if you want to clarify this point, you can, but I think at least there's agreement now on us moving forward, that the decision rests with us on what to recommend. Mr. Dejan and your team, you're fine?
No, Chair. We don't want to spoil the broth, Chair. I mean, you are the best cook.
Okay, thank you. We release you. Thanks for making time all the time that the committee asks you to come and advise. We always want to do things within the law and ensure that our decisions can stand the test of time. We also cannot pretend that in rebuilding the country, we are also learning from mistakes. That includes Parliament making such mistakes in decision making, as shown in other reports, including the Commission report. Will still need to deal with on the aspect of Parliament and how it played its oversight in that period. So everything we do, would really want to be sure at all times that we also do not go outside of what we need to do, which I think today you tried to keep us online so that we also don't tend to be a court of law. Thanks for that. Please be ready all the time when we really want your assistance. Thank you.
Thank you, Chair.
Thank you, Chair.
Honorable members, as we release the legal department, as I said, we will place on record what has been received in terms of public comments, because you'd remember that, like I said earlier on, when we received those just after the shortlisting, because remember, those were about us even removing people from the shortlist. And we said we will proceed whilst we give legal to look at the matter, and legal also agreed with us that we proceed because people would have passed the stage of shortlisting, which was about qualification and everything else, and that we move to the next stage, which is the interviews. As I said, whilst we're busy with that, there would have been public comments, which I take it that members would have received. And it is for that reason that at least they must just be placed on record so that there is no suspicion whatsoever that we may have hidden any matter that would have been raised when we finally make a consideration on who to recommend in that score. And as I said, immediately after that, we'll then take a brief report, in particular on qualification verification and the SSA vetting process. Ms. Ndabeni, if you can just place on record those that have been received post the four candidates that were spoken to, any of those that would have been received post that period for record.
Thank you, Chairperson. What we received post interview, the one for Mr. Dinkwanyane Muhuba, and as well as Ms. Baki, that was received during thank you, Chair.
I'm saying just indicate what has been received so that it's on record. Because we've also sent them to members.
Thank you, Chairperson. We received a comment on from SOS Coalition. We received another one from Public Interest South Africa. And we also received another one from the Property Practitioners Regulation Agency. Thank you, Chair.
Honorable members, may I just check if you received all those? So that it doesn't mention them. Mahuma one.
Received. Thank you, Chair.
Yes. There would have been, remember these matters were also placed to the candidates. And subsequent to that, there were clarities that were received. So that when those names are looked at, it must be understood were received. Also clarities in some situations. If you were to take, for example, Mr. Mahuba, there will be something received from the attorneys of the university, as well as his attorneys, to emphasize the point that you would have shared with the committee. The PPRA one is different in that it still talks to the candidate as having misled Parliament. So that's what I wanted to get put on record, that there were clarities given, as well as the part on the legal opinion now that what is done. So we'd have to note this as we will get to the deliberations as different parties, including the board assessment. May I also confirm if that was received, because as part of discussions that has been a point raised with many members of the board indicating that matters that are being raised are not consistent with the board assessment, which is public now in that score. So with that having been said, as I said, you would also get a sense of the vetting, which takes into account qualifications and the SSA vetting. Honorable Kola Barnett.
Thank you, Chair. Just a question to you. The documentation that was sent to us, the inputs from various entities, are those public documents or for the committee's eyes only? I presume they're public, but I just want your input on that. Thank you.
Yeah, it's just that then we don't have the legal. The understanding is that once it's public participation, it is the views of the public, which views they make them to be known. We've seen, in fact, some of these even in the public domain, whether you call it social media at this point, because they have been raised. And,
okay, thank you.
Committees have acknowledged them. Yes. So that's why I'm saying that people were asked in public and there were responses in public. And when they've clarified them, we shouldn't hide that those matters have now been clarified so that they don't prohibit us from making recommendations later on. So we don't want to get back to that debate when we have to deal with names. Honorable Lala.
Yeah, Chair, I think I'm covered on the public submissions, but the issue I wanted to find out is the board evaluation. I've not received that report from my side, but I've got two questions. Who did that evaluation? And what was our input on that evaluation? Because we are the people who are supposed to be doing the oversight over SABC. If it's done by the ministry, possibilities are that it's supposed also to feature in our committee so that we can also make our input. I don't know, but I heard you talking about the evaluation, the report of the evaluation of the current board, which in my view will be quite late to do that evaluation now. Even if there's a preliminary report, it will be noted from where I'm sitting, because if we start an evaluation process, because we need to make an input ourselves to that report. However, if I get a response, I think I'll be fine with that, and I'm okay.
Yeah, Honorable Mulala, again, as I said, a reminder there that this was raised by particular current board members who would have referred us to an independent evaluation done. From a committee point of view, the difference is that we wanted to see the SABC and look at our own matters, not merely maybe attendance of meetings and so on. We had particular topics wanted to deal with, even though they are exiting. And we said that will be part of a handover report that you can work on. So that let's make that distinction. We didn't do it ourselves because our focus will probably be something else. But the board itself may do this, of course, monitored by entity oversight. So I don't even want to say the minister in this case, but the board members were more referring to this, and we had interest as they talk to this evaluation. Now, very important when you consider people returning to office, whether they make progress or not. So I won't confirm that it's minister, except that it arose out of the interviews that we had with the board members. They all made reference to that. So that when you raise the issues you are raising about whether the board has performed or not, they were responding it in that way, that the evaluation done independently also is there for people to see. All that is just to assist you as you make your recommendations later on, that you've considered everything that is said to be available. You did not ignore what is raised with you. So it is in that sense. It is in that sense. So if you have not received one, would ask the committee support to still do that, because it will help you when you apply your mind later on the recommendations we need to make. Will that suffice? I take it that it's probably legacy hand because you are not speaking. I will then move to committee support. If you can get a briefing now on the verification, both the qualification verification as well as the vetting process from the SSC side. Is it me who's out of the platform?
No, I can hear you, Chair, and I can see you. I'm not sure what their situation is. Chair, I'm actually looking at the email, and Honourable Lesiba was included on the email with the SABC Board assessment report.
Yes, but as I said, with everything else that happens now, connectivity, energy issues, would still give benefit of doubt that the member may have not yet received that. And it's important to also give him an opportunity to look at it. Ms. Ndabeni, can we get a brief report on the verification process, which includes the SSA update?
Thank you, Chairperson. All candidates were sent the consent forms for HR qualifications check, as well as the SSA consents, and they were required to send those forms back, including fingerprints. The ones that were submitted, they are with SSA now, but indicated that they have a problem with their system. Currently, they don't have a system that is working, but they're trying their best to request assistance from the offices. So as soon as they have feedback on security checks, they will revert back to us. With regards to the HR, I have received most of the feedback on verifications check. All of them are positive, and the only ones that I haven't received, I've been following up with the candidates because they haven't sent me the consent forms to check, but it's only about 5 candidates that haven't submitted their consent forms, HR qualifications check. Thank you, Chair.
Thank you, Ms. Ndabeni. Honorable members, that's the update on the verification process. 5 candidates whose consent forms are outstanding on the part of qualification verification, but others positive. But as it relates to the SSA, the problem is more on that side, not on the basis of submissions. So that's something that has a bearing on the work we need to do, because there were members genuinely so were concerned that we tend to be embarrassed sometimes, that you make recommendations and find that there may be issues that arise out of that candidate that you put forward, and maybe that candidate would have been appointed. It also happens in the public service general, and then you have to do away with such a person because of failed vetting process. So we'll need to speak to this matter because it's important on our way forward. May I just check if there are clarities that members would want to ask at this point from Ms. Ndabeni's presentation before one maybe guides on what we probably should do as a way forward. Honorable Mlala, or is it a legacy hand?
Oh, it's a legacy hand, sorry, Chair.
Okay, thank you, Honorable Mlala. May I just check if there's any, thank you. I wanted you to say lower down then. May I then check if there's any, would want clarity, or it's quite clear? If everything else is clear, honorable members, I think we should then agree on a way forward. I want to put before you so that as you make comments, you also reflect on that. we have gone through the interview process, a very tedious process. And thanks for members who really stood up for all time until we're done with the business. Some of which would have been night vigils in their own way. Thanks for that. We've done our part, I think, in that regard. But this other part about the public participation, as we have discussed, does say that you may need to reconsider what should be the approach, and whatever recommendation to be made, it takes all that into account, so that when we capture it in the report, it's clear that it's not like we ignored, but we considered, but arrive at a particular recommendation that we're making. That's really also something. The second thing is that with the report given by Ms. David, who has not mentioned which are those 5 candidates, and you can imagine if all those other candidates thought should recommend in the 12 who have not signed consent forms in order for them to be verified. Now, this is important because in one of the candidates, there's been an issue of whether you have this qualification or you don't because of what has happened and so on. And the candidate had to clarify. So I'm making it as an example that from what the legal department talked about as the moral fiber issue that we still have to deal with when we put people in institutions, we have to be certain about those matters. So it may be an issue of going back to these candidates, at least make them aware that they are delaying the process and we may have no option but to leave them out if they can't consent that they be verified. When the advert was very clear that you'll subject yourself to that, including the vetting process. And maybe agree that we use probably other avenues to put more pressure on those that are responsible in assisting SSA. I'm not putting your neck on the block, Honorable Kolabana, to maybe serving in that other committee. But we really need them to move quicker on the basic vetting that needs to be done. It would appear now that the problem is the systems on the other side. So we also don't want to make recommendations really, and only to find that people will not pass just a basic vetting process, right? So in the score, I think, as I've said it also on the subcommittee platform, that even the program of Parliament, as you would have seen, has been piled up a bit because the programming committee could not put anything for a Friday. But in any way, we would not be able to present if there are still these matters that are outstanding. And therefore want to suggest that we note all these matters, agree that we give ourselves space, and we'll communicate this accordingly after we have consulted with the relevant offices, whether we can't get space, even if it is in the constituency period, just to complete the part on the names, having applied our minds on the information shared with us today, whether legal, whether the public comments that have been received, whether the outstanding matters from the SSA process and the qualification verification process. And that we communicate that. Of course, we'll take into account that part of the push for the dates was for two things. Those members who may not be available because they may be committed elsewhere in that period. Surely there can be arrangements in that regard, whether you bring on board a member from the party, as it has happened during the interviews where people are unable to make it, that a proper submission is done, and that at least at that time it would be names. And then the second issue was really that we do not want interim arrangements, but we want to have a board that can get proper handover from the existing board in a way that ensures smooth transition. I think if we can speak to the programming properly, it could still be done because your recess ends on the 10th and the board expires on the 15th. If we are able to get the dates we would want, that should help us a great deal. So that's what I want to put before you, honorable members, so that we check if there's agreement, so that it doesn't look like we're just about putting the names, even if the conditions are such that we have to consider certain matters that have been placed before us. Honorable Kolabana, I see your hand.
Thank you, Chair. Just one question. While I know it was quite a light aside, could I not put some pressure? I think from what I gather from the input, the vetting requests that went through have in fact been done and completed. It's the 5 members, not members, what do we call them? Applicants, who have not given their consent forms in. So I'm guessing it will be as quick as the others were if they should sign those forms. I find it very curious that they haven't. But you know, I don't think there's any point in asking someone to do something when they haven't been given permission to do it. So it's up to those applicants who have not finished their part of the process. So we're rather stymied by them. I think we need to give them a deadline by which they sign those forms, and if they choose not to do that, we must just simply remove them from the list. Thank you.
Another member? Any other member? I take it that your point, Honorable Kolabana, does not then disagree with the summary made, that indeed we need to give them deadline for submission, or at least understand that we can't then proceed with them. So, but that's on qualification.
Agree.
And then there's the part about the vetting is on the other side. The SSA side with functionality of systems, and therefore doing their best to work within what is available in the office to get this done. I think the same would go to them, that would want to have this before our next sitting where we look at names, at least to have this confirmed before we place the names on the table. And that would then make the communication on our meeting to deal with the names, taking into account everything else that has been shared with the committee, subcommittee today. Can we close it at that, honorable members?
No, you are seconded, Chair. We agree.
Agreed, Chair.
Okay, so that's agreed. I think any other matter surely would be for the next meeting. In the next meeting, it will really to just give the briefing as it relates to this subcommittee work, that we We have received the report from legal. We've considered public comments from the process. We would be applying our minds on that, and therefore in the next meeting then consider the names for which a report will be presented to the committee. I think that will be the long and short of what would indicate to the main committee. Other than that, it will be the briefing on the BDM, as you would have seen, minutes, and probably will be updated on the MTDA oversight. So that would be more for the committee. With that, honorable members, thanks for the contributions we've made. This meeting stays adjourned until we meet in the committee at 12:30. Thank you.
Thank you, Chair. Makosonke.
Yeah, no legacy hands. I want to point shortly.
Recording stopped.